The Court of Appeals, First Appellate District of Ohio is back in session.
Good morning. We have one case scheduled to be argued by Zoom this morning. That is State versus Marshall C240647. And I see that both counsel are present. Will you please unmute yourself, state your name and your readiness to proceed?
Judge Stephanie Kessler here on behalf of defendant, and we are ready to proceed.
Candace Creer on behalf of the state of Ohio. I'm ready to proceed.
Great, thank you very much. And if you will please keep yourselves muted when you are not speaking so that we can hear you clearly, and we will do the same. Ms. Kessler, would you like to reserve any time for rebuttal?
I would, Judge. I'd like to reserve 4 minutes.
All right, and you may proceed when you're ready.
I'd like to start today with the language of the statute, particularly the first 2 sentences. The first sentence is the one that says, if the court grants a motion for judicial release, the court shall do 3 things. That last thing is shall reserve the right to reimpose the sentence that it reduced. So the question here for us today is, what does that mean when it says the court shall do something? And what happens if they don't take any action? And I think the beginning of the second sentence helps us answer that question. Beginning of the second sentence is if the court reimposes the reduced sentence. And I think that if is really important. So when we look at a case cited to by the State v. Taylor, which is a first district case, the first district has a sentence in here that says, if a court reimposes an offender's prison sentence after revoking judicial release, the court can only reimpose the offender's original sentence with credit for time served. I find that reading that says the court can only reimpose the reduced sentence to conflict with this if language, right? So we see shall inside RC 2929.20 section K a handful of times. It gives us the first 3 shalls that the court must do if it grants a motion for judicial release. It says community control shall be no longer than 5 years. And if we keep going to the second paragraph in subsection K, we again see the court shall notify the appropriate person, the court shall notify the prosecuting attorney. So clearly the legislator here knows how to use the word shall. And what we don't see in this statute is a sentence that says, if a court finds a community control violation, the court shall impose the reduced sentence. We don't even see a sentence that says, if the court finds a community control violation, the court shall impose a sentence of imprisonment. The way that I read the statute to me is it's like there's a second sentence missing between those first 2. I don't think this statute on its face answers the question of, if the court finds a community control violation, can the court opt not to provide any additional sanction, just let things continue as they are? Can the court find a community control violation and increase the term of community control as long as that increase isn't beyond the 5 years set forth in the statute?
Well, counsel, didn't that happen with respect to Mr. Marshall? Wasn't there one prior violation for which there was no additional prison sanction imposed?
I am not sure about that. I didn't read that part of the record in preparation for today, so I apologize for that. But I think to the court's point, that seems like the court can do it, right? Because there's nothing in here that says the court has to impose this reduced sentence. It just says if. And I don't read anything in here that says a court can't do exactly that. Find a minor violation, give the defendant a warning, continue the terms of the community control. So I think these
Or would the court be within its power to, let's say, add a term or a condition of community control, for example, completing some kind of service or treatment program?
I would read the statute to say that a court has quite a bit of discretion to do those types of things. So I think
what do you make of the language in the entry granting judicial release that advised Mr. Marshall of the possibility of revocation up to 40 years?
I think that's a tricky question because 40 is clearly more than the sentence that she could impose if she reimposed the balance of the sentence. But that's not what the statute says. The statute says the court shall reserve the right to reimpose the sentence. And I don't think stating that she might impose a term of 40 years meets that reservation of the right in the record to reimpose the suspended part of the sentence. I mean, she certainly said that she would revoke it, and she certainly said that she'd consider a term of incarceration, but I don't think what she said meets that shall language of the statute.
What language would be required?
I think it'd be pretty express. I think it would either be, I reserve the right to reimpose the suspended sentence, or it could be, I reserve the right to reimpose the remainder of your sentence, or I reserve the right to reimpose the specific number of years, in this case, 7, that are remaining on your sentence. I think something like that, that we know what the court is doing, would be helpful.
Counsel, how is your client prejudiced by this error that you assert?
It comes down to the sentence that he would receive, and that depends on the remedy here if this court finds that the district court did not express or reserve that right. So I think the Evans court is on point here, and what Mr. Marshall would be subject to is a sentence under the community control statute. And I think that sentence could be less than the 7 years. So she finds that he violated his community control, and she is, as the Evans court suggests, limited in terms of the sentence of incarceration that she can impose for the community control sanction to what's in that community control statute. That sentence could be less than the 7 years that he is currently serving because his sentence was reimposed. So the prejudice would be he could have a shorter sentence. I mean, I think that's one of the other interesting things that the courts point out in their decisions is if we agree that there's quite a bit of discretion for the court in terms of what it's going to do in terms of violation for community control, well, then what happens if the court does want to impose a sentence of incarceration and the court hasn't reserved the right to reimpose the reduced sentence? What happens? And here, I think what would happen is that community control statute kicks in, and that becomes the court's guideposts for what an appropriate sanction could be in this case. And if there are no further questions, I will see the rest of my time.
Thank you very much. Ms. Creer.
May it please the court, counsel. The question is basically, what is judicial release? Is the trial court required to expressly reserve the right to reimpose the remainder of the defendant appellant's original prison term at the hearing at which it granted him judicial release? And if so, did the trial court fail to do so? So Ohio Revised Code section 292920 provides 3 shall statements. The court shall order the release of the defendant. The court shall reserve the right to reimpose sentence, and the court shall place the eligible offender under an appropriate community control sanction. These 3 actions the trial court must take. They are not optional. So in this case, the state will argue that it is implicit that the reservation of the remainder of the sentence in judicial release is there, but also the court explicitly states that they will send him back if he does violate, even though the first time he violated, he was not sent back for the remainder of his prison term. Additionally, in the entry, the court lays out that it would impose a prison term of 40 years if he does violate, though that
What's the impact of that error? Because I think we all can ascertain that number of years was incorrect, right? It was
Right.
That didn't reflect the actual number of years that the court could reimpose. So what is the impact of that error? Is that just merely a typographical error, or does that carry some kind of notice implication? Or does that undermine the trial court's compliance with the statute?
So when Mr. Marshall was originally sentenced, he was sentenced to 25 years. Everyone in that room at the judicial release hearing was aware that it was 25 years. It was stated on the record several times that he had served 17 and that he had approximately 7 years left in reserve. It was clearly a typographical error that resulted in no prejudice to the defendant because he was not going to automatically be sentenced to 40 years if he did violate this. And it was clear it was typographical also because the defendant was referred to as a she in the entry. It might have been a cut and paste issue, and it should have been resolved by a non-pro-tunc entry, but it was not. And going forward, it is clear that if there are issues with the sentencing court at judicial release hearings, there should be a way to cure those defects. And the way to cure those defects is not to say, you can no longer impose the remainder of the sentence, because that goes against the very nature of judicial release and Ohio law. That remainder of the sentence being reserved is not mandated to be reinstated if the offender violates the sentence. It is a safeguard. It is a sentence that allows the offender to be aware that they are still under that sentence. That sentence is there. It has not been expunged. It has not been wiped away. The court does not have the discretion to just leave the remainder of the sentence off the table. And when
And counsel, isn't the point of explaining to the defendant the sentence that's left on the shelf, as they say, to make sure that they understand they need to walk the straight line here, that there are going to be significant consequences if you violate those terms. Is that correct?
That is 100% correct, Your Honor.
And by saying it's going to be more than what it actually could be, you're even giving a stronger caution to the defendant.
It is. But in this case, it was a mistake, and 40 years was never going to be applied to Mr. Marshall if he did violate. But you are correct in that it was an amount of time that was reserved, that he knows he has the remainder of his sentence on the table and that he should comply with community control standards and to not violate the law. Unfortunately, Mr. Marshall did violate the law, and he was given another chance. So he did violate his community control sanctions, and he was not automatically given the remainder of his sentence. Only this time, when he was charged with possession of drugs, trafficking, did the court decide, no, this is something that needs to be dealt with by reimposing the remainder of his sentence, as well as providing a sentence for those charges. So, if there are no further questions, the state would cede the remainder of the time.
Being no other questions, thank you for your argument this morning.
Thank you.
Ms. Kessler, you have 8 minutes remaining.
And I'll be brief. It's not the court's role to rewrite statutes so that they make more sense. In this case, the legislature wrote the statute. They could have written, upon finding a community control violation, the court shall impose the remainder of the due sentence, or they could have written, upon determining a sentence of incarceration is necessary after finding a community control violation, the court shall impose the remainder of the due sentence. That's not what they wrote. So it would not be appropriate to then read that into a statute where it doesn't exist. In this case, the trial court quite simply did not follow the shall action. by reserving the right to reimpose the remainder of the sentence. And while I agree that the suggestion that she would impose a term of 40 years is most likely a typo, and it is greater than the 25 years that he had his entire sentence, I think we should be hesitant to put weight there because we don't know what defense counsel would have communicated to Mr. Marshall. It could be, and again, this is not in the record, but it's worthy of consideration, that when he turns to his defense counsel after the hearing, he says, oh my gosh, can't she really give me 40 years? Defense counsel says, no, she can't. And we don't know that a conversation like that takes place. We don't know if this comment of 40 years actually worked to the defendant to make him aware of the severity of the sanction that he could be facing, or if there was some sort of communication with defense counsel after the fact that would have negated that type of concern for a severe sentence. So I would encourage hesitancy in assuming the defendant's takeaway here was that he was facing quite a severe sentence. And with those two comments, if there are no other questions from this court, I will see the rest of my time.
Thank you very much. Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision. We appreciate your arguments. Enjoy the rest of your day.
Thank you.
Thank you.
The Court of Appeals First Appellate District of Ohio is now adjourned.